Hello. This video walks you through the new RECO Information Guide that as of December 1st, 2023 took effect as part of Phase 2 of the Trust in Real Estate Services Act, replacing certain regulations from the Real Estate Business Brokers Act of 2002, otherwise known previously as REBA. Some of these changes involve alterations in the seller's discretion regarding what information they choose to disclose during an offer presentation, the introduction of designated agency where a brokerage can represent multiple clients simultaneously, and what we'll explore today, the RECO Information Guide on working with a real estate agent. It's important to note this guide is now mandatory for all buyers, sellers, landlords, and tenants. If you're watching this, you've likely received a copy of this booklet, either digitally or in person. The purpose of this video is to walk you through each page of the guide, covering every essential aspect, and you're welcome to follow along with your physical or digital guide. My name is Morgan Little. I'm a realtor here in the Greater Toronto Area. If at any time you have any questions about this guide or your real estate journey in general, feel free to book a call using my Calendly link in the description below, and I look forward to connecting. Or you can go onto RECO's website, which will be linked below, reco.on.ca. I understand this is lengthy, but it's mandatory info for myself as a realtor to share with you, and it's for your benefit as someone working with a realtor to understand everything involved. Now, let's get into the guide. Here's a little information about this guide. You've received this guide from a real estate agent because you're considering receiving services from the real estate agent, or the agent is representing a client in the transaction and you might receive assistance from the agent. Real estate agents in Ontario are required to walk you through this guide before providing services or assistance to you. In this guide, a brokerage means a real estate brokerage. A real estate agent or agent means a real estate salesperson or broker. You and client mean a buyer or seller. Buyer and seller can also mean lessee or lessor, respectively. Moving on to working with a real estate agent. Agents in Ontario must be registered, which requires completing the necessary education and carrying consumer deposit information and professional liability insurance. Real estate agents provide valuable information, advice, and guidance to buyers and sellers as they navigate the complexities of a real estate transaction. If you are a seller, an agent can advise you on market conditions and the best strategy to attract buyers and get the best price for your home. Market or advertise your home, including arranging photographs, videos, and virtual tours. Provide referrals to other professionals you'll need, like a lawyer or a home staging company. Arrange and attend home inspections and appraisals. Arrange showings for interested buyers. Advise you on how to handle competing offers, sharing the content of competing offers and other aspects of the transaction. Vet offers and potential buyers to ensure they can afford to buy your property. Negotiate with buyers to achieve the best results, price, and terms for you. Guide you through paperwork and closing the transaction successfully. Now, if you're a buyer, an agent can assist you with getting pre-approved for financing so you know how much you can afford, make you aware of any tax exemptions you might be eligible for, gather and share info about neighborhoods and homes that meet your requirements, make inquiries about zoning, permitted property use, and other aspects of the home. Advise you on the best approach in competing offer situations and how to protect your offer information. Negotiate with sellers to achieve the best results, price, and terms for you. Guide you through paperwork and closing the transaction successfully, and provide referrals to other professionals as mentioned previously. You will also benefit from the duties the brokerage and agent owe to you as a client. Undivided loyalty. Your best interests are promoted and protected by the agent and the brokerage. Disclosure. They must tell you everything they know about the transaction or the client relationship that could have an impact on any decision you make. Confidentiality. Your confidential information cannot be shared with anyone outside the brokerage without your written consent, except where required by law, even after your client relationship ends. This includes, for example, your motivation for buying or selling, or the amount you'd be willing to pay or accept. Avoid any conflicts of interest. They must avoid any situation that would affect their duty to act in your best interest. If a conflict arises, they must disclose it to you and cannot provide any additional services to you unless you agree in writing to continue receiving services. You have responsibilities as a client as well. You need to be clear about what you want and don't want, and make sure you share all the information that might be relevant. You must respond to your agent's questions quickly. understand the terms of your agreement with the brokerage, and pay the fees you have agreed upon, even if the agreement to buy or sell later falls through because of your default or neglect. Knowing your risks of representing yourself, which is now a thing. If you are involved in a real estate transaction and you are not a client of a real estate brokerage, you're considered to be a self-represented party. This means you have chosen to represent yourself, which has different rights and responsibilities. Very few buyers or sellers make this choice. There are significant risks to representing yourself in a real estate transaction. If you do not have the knowledge and expertise required to navigate the transaction on your own, you will be dealing with a seller or buyer who is benefiting from the services, opinions, and advice of an experienced agent where you would not be getting those. RECO recommends that you seek independent professional advice before you proceed as a self-represented party. If you choose not to work with a real estate agent, it will be your responsibility to look after your own best interest and protect yourself. This may include things like making inquiries about zoning, permitted property use, etc. to cities, determining what you believe will be the value of a property you're buying or selling, determining how much you're willing to offer or accept, navigating competing offers, deciding what terms you want to include in an offer, agreement, or purchase and sale, and preparing all documents. The real estate agent is working for another property in this transaction. It's important for you to be aware that the agent has a legal obligation to act in the best interest of the person on the other side of the transaction. If you're a buyer or if you're just inquiring about the property, for example, the agent is working for the seller. The agent then has a duty to do what's best for their seller client. Be aware that the agent is obligated to share anything you tell them with their client, which might not be in your best interest, including your motivation for buying or selling a property, the minimum or maximum price that you're willing to offer or accept, and your preferred terms and conditions. The agent cannot provide you with any services, opinions, or advice, do anything that would encourage you to rely on their knowledge, skill, or judgment, encourage you to represent yourself, or discourage you from working with another agent. And any assistance the agent does offer you is a service to their client, not to you, and is in the best interest of their client, not you. It is to help their client to buy or sell a property. The agent must give you this document, RECO's information and disclosure to self-represented party form, and walk you through it before they can provide you with any assistance. You'll be asked to confirm you received this and understand that it means you are a self-represented party in this situation. You also have the right to change your mind. When you're signing a contract with a real estate brokerage and you become a client, you sign a representation agreement. This is a contract between you and the brokerage for real estate services and representation. If you don't want to sign an agreement, you should not expect the agent to provide you with any services like showing you homes. Representation agreements can be called buyer rep agreements or seller rep agreements or listing agreements. Your agreement must be put in writing and presented to you as soon as possible. Protect yourself by reviewing the agreement in detail. This will help avoid any misunderstandings between you and your agent. What to look for in a representation agreement. Your representation agreement should describe the duties owed to you, the services you'll receive, your rights and responsibilities, what you'll pay, and any specific terms that are to be included in the agreement. Here are some key things to look out for. The name of the designated representative. If the contract is designated representative agreement, the name of the representative will be included. More than one agent can be working for the brokerage and can be identified as your designated representative. The scope. Your agreement should specify the scope of the engagement. If you're a seller, this means the agreement will identify the specific property. If you're a buyer, you should consider the scope of the agreement very carefully. Your agreement might identify a specific property, a geographic area, a type of property, or any other specific requirements. For example, if you're looking for both a house in a particular city and a cottage property near a lake, you'll want to include all of that information in the scope. We'll scoot back up here where we missed. There are two kinds of representation agreements in Ontario. Brokerage representation. The brokerage and its agents represent you and must promote and protect your best interests. But one of the brokerage's real estate agents may be your primary contact. They may provide you referrals to other professionals, etc., as we mentioned earlier. Designated representation is where one or more of the brokerage's real estate agents is your designated rep. The agent reps you and must promote and protect your best interests. The brokerage and its other agents are required to treat you impartially and objectively. An important aspect of designated representation is that it reduces the likelihood of multiple representation. We'll read more about that in the future document here. Designated representation was introduced in Ontario as of December 1st, 2023. This is new. Moving on to services. The agreement must clearly set out the services you'll receive. There's no standard set of services. Brokerages offer a variety of service options. You might enter into an agreement with a brokerage for a specific purpose, like having an agent prepare an offer on a property you want to buy or viewing a specific property. Some sellers enter into an agreement solely for the purpose of having their property advertised on a local listing service. Ask the agent about the available services or combination of services that might be right for you and your situation. If there's a specific service that you need or expect to receive, make sure it's included in the agreement or as a schedule to the agreement. Don't assume that a particular service will be provided if it's not included in the agreement. Payment amount and terms. You and the brokerage decide the amount that you'll pay for your service. The amount is not fixed or approved by RECO, any government authority, or any real estate association. You can agree to pay a fixed dollar amount, a percentage of the sale, or a combination of both. The representation agreement cannot specify an amount based on the difference between a property's listing price and what it sells for. Agreements must also identify circumstances in which the amounts agreed to might change and how they will change in each circumstance. If you're a seller, your agreement needs to clarify the amount you agree to pay the brokerage or how it will be calculated for the services, the amount or how it will be calculated you agree to pay, if any, to compensate the buyer for their brokerage fees, and how the amounts you agree to might change if consent to multiple representation is agreed upon. If you're a buyer, your agreement needs to be clearly indicated the amount you agree to pay your brokerage or how it will be calculated for the services and representation you receive, how the amount you agree to pay will change if the seller agrees to cover some or all of the brokerage fees, and how the amount you agree to pay might change if you consent to multiple representation. Important note for buyers. A seller might not offer any amount to cover the fees you owe to your brokerage under your agreement. This could affect the amount you're able to pay or offer for a property. Depending on your financial circumstances, you might not be able to afford to buy a property when the seller does not agree to pay your brokerage fees. Termination provisions. The agreement should list all circumstances when the agreement can be terminated. Review when the brokerage can terminate the agreement and make sure you're aware of any penalties or costs that might apply. Two important circumstances to be aware of. Multiple representation. You do not have to agree to multiple rep, and your agreement should be clear about what happens in this situation. For example, the agreement could terminate completely, or you might have been referred by another brokerage or designated rep for that specific transaction, but otherwise remain under the agreement with the brokerage. Changing your designated rep. If you have entered into a designated rep agreement, the brokerage cannot appoint a different rep unless you agree. The brokerage may ask you to appoint someone else if, for example, your designated rep stops working at the brokerage. Expiry date. The agreement's expiry date must appear prominently on the first page. There's no set time or standard term for a representation agreement. It can be in place for a day, a few weeks, months, or consider how long you want the agreement to remain in place. Just make sure that you know when it will expire. Keep in mind that a holdover clause could mean you owe money even after the expiry of the agreement. Most representation agreements include what's called a holdover clause. This clause may require you to pay the brokerage fees for a purchase or sale even when the transaction happens after your representation agreement expires. The clause will specify the time the holdover clause is in effect. It's designed to protect the brokerage, and there's no minimum set time for the holdover period. If your agreement includes a holdover clause, make sure you agree to the length of the holdover period before you sign it. And this is to protect the brokerage in case they introduce you to a buyer or seller during the time that the agreement is in place, but the purchase actually happens shortly thereafter. Understanding multiple representation. Multiple representation means a designated representative or brokerage represents more than one client with competing interests in the same transaction. This can happen in different ways depending on the type of representation agreement that you and the other clients have with the brokerage. Brokerage representation. Multiple representation exists when the brokerage represents both the buyer and seller in the same transaction, or two or more competing buyers interested in the same property, even when the clients are working with different real estate agents. Whereas designated representation, multiple representation exists when the same real estate agent is the designated rep for both the buyer and the seller in the same transaction, or for two or more competing offers interested in the same property. Multiple representation is not permitted unless each of the client involved agrees. You should seek independent professional advice, for example, from a lawyer before proceeding. The brokerage or your designated rep has a duty to promote and protect your best interests and avoid conflict of interest. If your brokerage or designated rep enters into an agreement with another client who has an interest in the same property as you, this places both clients in multiple representation. Multiple representation introduces risks to you and the other client. It's important to understand the risks. If you agree to multiple rep, the brokerage or designated rep must treat each client involved in an objective and impartial manner, cannot maintain loyalty to you or promote and protect your best interests over the interests of the other client, and cannot offer advice to you about such things as the price you should offer or accept or terms that should be included in an agreement. What to expect before you agree to multiple representation. The brokerage is required to provide you with a written disclosure that explains how the brokerage's duties or the designated rep's duties will change to you, the difference in the services you'll receive, and any change in how much you pay the brokerage. Until this information is disclosed in writing to all clients in the transaction and they all agree in writing, the brokerage or designated representative cannot take any further steps on behalf of any of the clients. Confidential information you provide to the brokerage or the designated representative when you're represented cannot be shared without your written consent, and you can refuse multiple representation. If you don't agree, the brokerage or the designated representative is not allowed to proceed. Ask the brokerage or the real estate agent about alternatives to multiple representation. For example, if you're a buyer, the brokerage could refer to you to another brokerage or to another designated representative to help you make an offer on the property. This is new this year. Agreeing to multiple representation significantly reduces what the brokerage and its agents can do for you, which could have consequences and costs. A note about content of other offers. You may have seen articles in the media about open bidding or an open offer process. Buyers in Ontario who have made an offer on a property are entitled to know the number of competing offers. Sellers choose how much other information, if any, they want to share about these offers they receive. If you're a seller, you decide how much information you want to share about competing offers. Your agent will advise you based on the characteristics of the property, market conditions, the content of the offers you receive, and other things. You need to provide clear written direction to your agent before the content of any offers can be shared. Personal or identifying info contained in other offers cannot be shared. Now, if you're a buyer, you decide whether you want to participate in a process where the content of your offer might be shared with other buyers. Your agent can tell you the steps to take to avoid having the content of your offer shared with others. Be aware the seller can make the decision to share the content of offers at any time, and you may not know in advance. Now, the last part of this document is about how to make a complaint. Brokerage firms and real estate agents working in Ontario must be registered with RECO. Ontario brokerages and real estate agents are accountable for their conduct. If you have a concern, first contact your brokerage. In many cases, your brokerage will be able to mediate or resolve your complaint about a real estate agent or the services provided under your representation agreement. Search for the brokerage in RECO's public register to find the name of the broker of record. He or she is the person responsible for ensuring the brokerage complies with the law and their contact info. Note that the brokerage cannot ask you to sign an agreement that requires you to withdraw a complaint to RECO or prevents you from making one. Here is the contact info for RECO. You can read that yourself. Links to this will be in the description below. And here's the acknowledgement portion that you will then sign off on once you've reviewed the document. Now, if you made it this far, thank you. I appreciate your time as we went through this. As I mentioned, this guide is now mandatory inclusion for all buyers, sellers, landlords, and tenants in Ontario as of December 1st, 2023. If you have any questions at all or need further clarification about this guide, or again, just about your real estate journey in general, feel free to book a call with me using my Calendly link in the description below, and I look forward to connecting. Till then, stay well and stay hungry.